Hey everyone, it's Alex from BizLaunch. One of the most important decisions to make when you're planning to start a business is selecting which legal entity you're going to be. In the United States, there are 6 different types of business entities in which to choose. However, what are the legal ramifications and tax implications for each? Check out our segment where you'll hear from legal experts from George Mason University for an overview of the 6 legal entities in the United States, along with their tax implications for each.
Well, thank you, Alex, and welcome to everybody online. Uh, we're really enthusiastic about meeting all of you this way and having the opportunity to share a little tax knowledge with you. Um, I am joined this morning by uh, my colleagues, Mitch Gibson and Rebecca Haynes, who are both third-year law students at the Scalia School, the George Mason University Law School in Arlington. And here is the agenda of what we plan to cover this morning. We're going to talk mostly about the different ways to use different types of entities for your emerging business or your small business, and then what it looks like when you succeed and look for an exit strategy, what the tax consequences look like when you try to sell that small business to somebody else. Mitch Gibson is going to start us out, and then we'll switch to Rebecca Haynes when we switch to the corporation subject. We probably we'll have time at the end for as many questions as you want. We'll stay a little late if necessary, so feel free to send us questions on the chat function, and we'll try to take them all at the end of the presentation. And with that, I'm going to turn it over to Mitch, and Mitch, just signal me when you're ready to change the slides.
Will do. Good morning. As Professor Silverberg said, I'm Mitch Gibson, and I'll be talking about non-corporate pass-through entities. So next slide, and you can actually go 2 slides, Professor Silverberg. So we're going to start with the simplest non-corporate business entity, which is a sole proprietorship. And the way that you can think about this is if a child decided to do a lemonade stand. They're the only one running the business, and all of the money is going directly to them, and they aren't registered with any state authority. The next kind of business entity is a partnership. So say the child's best friend decides to join them for business, and they start operating together and splitting the money they make. That would be a partnership. And it can have as many people as the two, or as many people who want to participate as possible. And it also doesn't need to be registered with the State Corporation Commission. Next slide, please. So the next structure that I'll be talking about is a limited liability company, or an LLC. And this is a registered entity. It's statutorily authorized, and it limits the liability for its members and managers. And the members are people who own a stake in the company. So this would be similar to shareholders in a corporation. Managers are either members or outside individuals who take care of or manage the business dealings of the business. And so an LLC can be either member managed, so everybody who is invested in the business takes part in making business decisions, or it can be manager managed. And so a member managed LLC, the investors are active investors. manager managed. Most of them investors are going to be passive investors. Next slide, please. So if you decide you want to be a sole proprietorship or a partnership, how do you form that and start doing business? And you just do that. You just start. Since you don't need any authorization from the state, you can begin doing business today if you wanted to. It is important to remember that some businesses require licenses, permits, registering the business name, or zoning clearance before you can begin. If you don't comply with these, there can be a fine, sometimes a very hefty one. For example, if you don't register the name that you're doing business under. So for a lemonade stand, let's say they decided to go with Arlington Lemonade and aren't operating underneath the names of the two children who own the lemonade stand. The county could come in, or state could come in and give them a fine for not registering that name. And that fine can be up to $200 or $2,500 or a year in prison. So you really want to make sure that you take care of that if you're not going to be operating underneath your own name. And if our two kids decide they want to hire a third to help take care of the lemonade stand, but that person isn't going to be a partner, they need to make sure they have an EIN or employer identification number for tax purposes. And you get that from the IRS. Next slide, please. So there are some particular issues with partnerships that I want to go over. So having a partnership agreement in place before you start business is always a good idea. So a partnership agreement can cover a lot of things. It can be talk about how decisions will be made, if there's an even number of partners and each gets and they all get equal say, and say it comes out to a tie, how is that tie going to be broken? Which partners can bind the partnership for what issues? How gains and losses will be divided. So all these things can be included in partnership agreement. They don't have to, but having that formal agreement in place protects both the partners if something were to go sour in the future, and it can also help the partners clearly understand what their role is going to be in the business and what they can depend on each other to do. And this can be a great way of saving future relationships. So if you include how gains and losses will be divided within the partnership agreement, courts will generally respect those terms so long as they're not done for solely for tax purposes. And if you decide not to include that in your agreement, the default is that gains and losses will be divided equally between the partners. Next slide, please. So to form an LLC, you need to complete Form LLC-1011 and file it with the State Corporation Commission. But there are some professions like doctors, architects, or lawyers who should complete Form LLC 1103, and that allows them to become a professional limited liability company. There's not really a difference other than what profession is being formed. And the LLC should also get an EIN from the IRS. Next slide, please. Okay, so at the start I said that these are non-corporate pass-through entities. So what is pass-through taxation? Next slide. Pass-through taxation means that the business itself is not taxed on the income that it receives. Instead, all gains and losses are taxed at the owner level. So with our lemonade stand, the two owners will be taxed for all the proceeds that they earn over the year. And pass-through taxation can be used for all of the entities that I've described, as well as S corporations, which Rebecca will talk about. The only type of business entity that can't use pass-through taxation are C corps. Next slide. Okay, and so I want to go over a few of the advantages and disadvantages of using pass-through taxation compared to C corps. And the biggest advantage that most people know about is a single level of taxation. If you're a C corporation, the corporation is taxed, and then as that money is distributed to the shareholders, it is taxed again. That doesn't happen with pass-through taxation, since it goes directly, or it's seen as the money going directly to the owners of the business. There's one level of taxation. You can also get pass-through losses. So that means if the partnership loses money through the year for whatever reasons, the partners can use that loss to diminish their tax burden from other areas of income. So say they earn a salary from their partnership, and then the partnership as a whole has losses, they can decrease the amount of that salary that will be taxed. But there are some caveats with the pass-through losses. There's limits that can be attributed to members of LLCs. And then there's also the qualified business deduction. As the name implies, only qualified businesses can receive the deduction, so it's important to determine whether your business would qualify before attempting to take that deduction. And because it's a little more complex, we don't want to go into all of the specifics of that, but we encourage you to look into that before filing your taxes with your new business. Some of the disadvantages of pass-through taxation, first is liquidity or phantom income. So this occurs when your business has made a profit for the year, but that money is kept inside the business and isn't distributed to the partners, members, or sole proprietor. When this happens, the owners are still going to be taxed on that income, even though they haven't received any of it. So your tax burden doesn't accurately reflect your personal economic situation. Tax consequences can also dissuade certain types of investors. So if you're looking to have like a venture capitalist come in, they're going to be a lot less likely to want to have some of the tax consequences that come with pass-through taxation. Pass-through losses are nice, but they don't want to necessarily be paying taxes for the income that the business is receiving, particularly if it's not being distributed. So depending on what your goals are for your business and how you plan on raising money for the venture, pass-through taxation can be a disadvantage. You can also only deduct $10,000 of state or local taxes per member or partner. So this would happen if the member or partnership does an itemized deduction rather than taking the standard deduction. So you could have a greater tax burden than the $10,000 per member or partner, but there is that cap set. And so that can be a disadvantage as well. And there's also the potential for a self-employment tax. And we'll talk about that a little bit later with some of the other employment tax issues that can occur. That's all I have. So we'll go ahead to go to Rebecca.
Hello, My name is Rebecca. I will be discussing corporations. So, next slide. So to start off with, can corporations have pass-through taxation? Next slide. Yes, so corporations can elect to be taxed as an S corporation and be treated as a pass-through entity for tax purposes. Slide. And then again. So what is an S corp? You don't incorporate as an S corp, rather you incorporate as a corporation. An S corp isn't an actual entity type. You just elect to be taxed under subchapter S of the tax code. That's why it's called S corporation. And an S corporation is like pass-through entities that Mitch discussed earlier. The incomes and losses pass through to shareholders for federal tax purposes. And so you will pay on your individual tax returns and your individual tax rate the portion of the income and losses from the company. Slide. So how to form an S corporation? First, you would incorporate in the state of your choice, simply as a corporation, and you should ensure the corporation meets the requirements to become an S corp. There are some restrictive requirements that I will discuss on the next slide. And you should submit Form 2553, election by a small business corporation, by the applicable deadline. The deadline depends on whether or not you have a prior tax year or not. So if you're a C corporation with a prior tax year and you want to elect to become an S corp, beginning with the next tax year, you should file by March 15th. The deadline's usually in mid-March, depending on the exact date depends on whether or not you have a prior tax year. And the form must be signed by all the shareholders. Slide. So the requirements to become and remain an S corp are that you must be a domestic corporation. You can only have certain shareholders. They have to be individuals, certain trusts or estates, meaning that partnerships, corporations, non-resident aliens cannot be shareholders. You cannot have more than 100 shareholders, and you can only have one class of stock outstanding. You can also not be an ineligible corporation listed there. And if the company violates any of these requirements, the company will cease to have S corp status and will automatically be converted to a C corp. Next slide. So, comparing the S corp to other pass-through entities. So, first, how is an S corp similar to pass-through entities? Like other pass-through entities, there's a single level of tax. As discussed, the company's gains and losses pass through and are taxed once at the shareholder level. There's also the benefit of pass-through losses, which can be beneficial as the losses may offset like other income on the shareholder's tax return, and they're limited to shareholder basis at-risk rules, passive activity loss rules. And there's also the qualified business deduction that Mitch mentioned earlier that applies to pass-through entities, including S corps. And so the way an S corp is different from other pass-through entities is it allows for tax-free reorganizations. Unlike LLCs, corporations can engage in reorganizations with other entities in a way that eliminates all corporate and shareholder level taxes that stem from the reorganization. And there's also the ability to provide stock options. So the provision of stock options for an S corp is far less complex than in an LLC. And S corporations can adopt both traditional stock options and incentive stock options. And options are valuable for a company because it gives them the ability to compete for and procure talent with stock options. But it's important to note that because an S corp can only have one class of stock outstanding, it's important to make sure the exercise price is not too far below the fair market value of the option on the grant date. Otherwise, the stock option may be classified as a second class of stock, automatically nullifying S corp status. And then that brings us to the easy conversion to a C corp. So if there comes a time when you want to switch to C Corp status, you can easily convert to a C Corp. Say you obtain VC financing or financing from foreign shareholders, the S Corp will automatically convert to a C Corp because the requirements I mentioned earlier have been violated. On the other hand, with an LLC, any conversion to the corporate form in order to take your company public must be made well in advance and with more work. Next slide. So C corporations. So a C corporation is just a regular corporation. Corporations are by default taxed under subchapter C of the Internal Revenue Code. Why it's called a C corporation. And so they're a separate entity distinct from its owners, and it's taxed separately. And the only way to form a corporation is through compliance with the state incorporation statute. And so a corporation can be closely held, which means it has only a small number of shareholders, or it can be publicly held, having a large number of shareholders and shares sold on the public market. And then some states have separate provisions for the organization of closely held corporations, which enable owners to dispense with some of the corporate formalities that are inherent in managing a corporation. Next slide. So, what most people think of when they think about corporations and taxes is double taxation. So, a corporation is subject to federal income tax separately from its owners. And so, the corporation's tax is a flat 21% tax rate at the entity level. And then the profits accumulated after the corporation pays that tax is subject to further federal tax on the profits that are distributed to the shareholders as dividends. And so the tax rate for that would be 20%, would be a matched 20% tax rate on distributed dividends taxed to the shareholder. And so if the corporation distributes earnings to shareholders, those earnings are taxed twice, once at the corporate level and again as individual earnings, making the effective tax rate on those distributions to be 41%. And so now there's an exception to for qualified business stock held for more than 5 years after issuance is eligible for a 100% exclusion from gain on disposition, not to exceed $10 million or 10 times the taxpayer's basis for any one shareholder. So what is qualified business stock? Qualified business stock is issued by C Corporation at its original issuance. The C Corporation must be engaged in an active business, and the gross assets of the corporation do not exceed $50 million. So this exclusion often makes C corporations attractive for businesses likely to reinvest its operating proceeds. Next slide. So as a comparison between the C Corp and the S Corp, just to review. So the C Corp has double taxation, as I discussed earlier. And there's also the retention of operating capital. Equity holders and LLCs and S Corps usually insist on distributions of cash so as to pay taxes on their portions of the company's taxable income. Nick spoke a little bit about this when he spoke about phantom income. And C corporations are generally able to offset their earlier tax losses because for a period of time, allowing the company to shelter its cash during its development and thus conserve more operating capital. So if you're a business and you anticipate needing early and continued expansion of your business, you may wish to form a C corporation for this reason. And also, C corporation can issue more than one class of stock. There's exclusion for gain from certain small business stock that I spoke about, and there's unlimited deduction of state and local taxes. And then an S corp has single level of tax, like all other pass-through entities. They have pass-through losses, qualified business deduction, and there are strict limits on the provision of stock options and the availability of VC funding. So, yeah. And also the deduction for state and local taxes is limited to $10,000 per shareholder.